Hi, this is Mike Young, estate planning and probate attorney in Walnut Creek, California. And I'm going to answer the question I get a lot, and that is, which document has priority, the revocable living trust or the will? And the other question I get is, why do I have a revocable living trust and a will? So before I start, hit the subscribe button below and the bell so that you'll get notice of future videos I prepare. Also hit the like button and leave a comment if you like. And before I forget, I put workshops on the second and fourth Thursday of every month at 10 a.m. Zoom workshops. And you can go on my website, walnutcreekelderlaw.com. I'll leave a link to it below, and sign up for one of my workshops. They are Zoom workshops and they're interactive, and participants ask questions and we have nice conversations. So I encourage you to sign up for my Zoom workshops, and they're on estate planning, beginning estate planning, advanced estate planning, probates. We talk about Medi-Cal and asset protection. So with regard to the question, which document has priority, the revocable living trust or the wills? So let's say my clients are Bob and Mary Smith. And let's say Bob and Mary Smith buy a home in Walnut Creek, California, and they take title as Bob and Mary Smith, husband and wife, as community property. Then they come to me and they want an estate plan. They want to avoid probate. They want a revocable living trust. They want their family and their children to control the assets. And so I would create a deed from Bob and Mary Smith, husband and wife, as community property, to Bob and Mary Smith as trustees under their revocable living trust. So the name of the trust would probably be the Bob and Mary Smith Revocable Living Trust. So now by a deed transfer, which we record with the county recorder, we have transferred title of the home to Bob and Mary Smith's Revocable Living Trust. And the trust says if Bob dies, the home stays in the trust for the benefit of Mary. If Mary dies first, the home stays in the trust for the benefit of Bob. And when they're both dead, the trust says that the home will be sold and proceeds of sale will go to their three children, Ken, Barbie, and Rasputin. So we've controlled that asset, Bob and Mary Smith's home, through the trust, and we did not have to go to court. So as part of their estate plan, they have their revocable living trust, and Bob and Mary Smith each have a will. And the vernacular for this type of will, which is part of this trust-based estate plan, is pour-over will. So you won't see that term in the wills. But the revocable living trust for Bob and Mary Smith references the pour-over will, and the pour-over wills reference the trust. And the time that we would use this trust would be if, for instance, let's say Bob died and then Mary died, and the children are doing administration of the trust, and they're looking for all the assets that their parents had. And they come across a bank account that Mary had that she never told anybody about. And there are no further beneficiaries named on that bank account. So now the bank has no authority to make the distribution of the $200,000 in Mary's bank account to anyone. So now we can take Mary's will, file it with the probate court, and the probate court is going to want to know, well, what is the asset or assets of this estate for Mary Smith. So we list on the petition, the only asset for this estate in probate court is Mary's $200,000 bank account. And then we put on the petition who is the beneficiary then of the will. So we file Mary's will with the court, and the beneficiary is, in essence, Bob and Mary Smith's Revocable Living Trust. So now we petition the court ultimately for a decree of distribution or an order transferring that bank account that Mary had for $200,000 or whatever it was to the Revocable Living Trust. So now the home and the $200,000 can be distributed to Bob and Mary Smith's 3 children, Ken, Barbie, and Rasputin. So the home was controlled by the trust. The trust had priority. That errant bank account of Mary's, the document that had priority there, was her Revocable Living Trust. So that's how the 2 documents, the Revocable Living Trust and the wills, work hand in hand. So which one has priority depends on the asset that we're working with. So that also answers the question I get, Mr. Young, why do we have a Revocable Living Trust and wills? So that's what the wills are used for. So let me share my screen with you. So my website is Walnut Creek Elder Law, and you can go on my website to find more information, walnutcreekelderlaw.com. And as I mentioned, I hope you sign up for my workshops. I think they're kind of fun, and they're interactive. So I would like to thank you for watching. If you want to email to me, the email is lawyoung1@gmail.com. I'll leave a link, and my website is walnutcreekelderlaw.com. So thank you very much for watching.